cover section 138?
Or 138 is also, it is for recovery of a debt.
Sorry,
in a
sir.
sense, in a sense,
Sorry,
because
sir. Wait for 2 seconds. Right? Or else I am ready to keep quiet. No difficulty.
No, my lord. I would.
If you have decided that you will speak out only and you will not listen to the court, fine, sir. No difficulty.
No, my lord.
We cannot compel you to listen to me.
I'm sorry, my lord. My
भाई
lords, and-
प्लीज यार, आपके पास कॉमा फुल स्टॉप नहीं है क्या?
I'm sorry.
नहीं है तो फिर बात करो, हम भी चुप रह जाते हैं.
I'm sorry, my lord.
समझ में आ गया क्वेश्चन मेरा? नहीं आया तो मैं समझाऊं.
Sorry.
I don't know, sir. Whatever you have produced, that I'm. Mister, please
My lord, I would produce.
don't raise your voice. You have not filed the documents.
The last-
Final, Mr. Counsel, please bear with me. If you have chosen not to file the document, then don't shout at me.
I'm not shouting, my lord. I'm sorry, my lord, if my
कितना अमाउंट डिपॉजिट करने के लिए बोला है?
my lord, the deposit. My says that the order is itself barred by law, my lords. There is a specific moratorium under section 96 of the IBC which says that any debt is the proceedings are stayed. So therefore, the judgment which has been passed by the trial court itself is without jurisdiction, my lords. So therefore, there can't be. That is a specific ground which has been taken in appeal also. My
Just a minute.
lords.
आप ये बताइए कि अब आपने तो बेल ऑर्डर का है ना?
My lord, it's
क्या क्या
suspension.
आपका?
Suspension.
आपका भी ग्रीवेंस किस ऑर्डर किया गया?
But against the order dated 16/4/2024, whereby the condition has been put forth by the appellate court for suspension of sentence to deposit the money.
Right.
My says when the judgment itself is bad in law
Hmm.
and barred by law, my lord, specifically, if my lords would see what is the provision under section 96, I had quoted in my petition, my lords,
96 of
90 of IBC code, Insolvency and Bankruptcy Code 2016.
ये कहाँ से आ जाएगा?
It would apply. That's what I'm saying, my lords. If it would read, my lords, it says, I had quoted at page 13, my lord, ground 2 of my petition. I had quoted, if my lord would require, I would just, may I pass on the book also?
नहीं, I will rely on देना, उसे किताब देना.
Take it.
Section
96, my lord.
जी सर, interim moratorium.
Interim moratorium, my lords.
Mhm.
It says 96(1), when an application is filed under section 94 or section 95A, an interim moratorium shall commence on the date of the application in relation to all the debts
Mhm.
and shall cease to have effect on the date of admission of such application. And B, during the interim moratorium period, any legal action or proceeding pending in respect of any debt
Mhm.
shall be deemed to have been stayed.
Mhm.
So I am paying emphasis.
Whether offense under section 138 of
That has been covered by the Honorable Supreme Court in case of P. Mohan Raj and thereafter in case of
बताइए.
my lords. And subsequently, the Punjab and Haryana High Court has taken a view, my lords. First, I would just bring my lords' attention to this is the latest judgment of 2022. Vijay Kumar Ghai, my lord. Last paragraph I had quoted.
What does it say?
It says that interim moratorium would apply. Para 86, my lord.
Mhm.
But the last 4 lines are very. If my lord would see, I would read the entire one. On the proceedings in the complaint filed by him under section 138 of the proceedings in the complaint filed of the act, comma, by virtue of the interim moratorium stipulated in section 96 of the code, there would seems to be no option with this code but to allow the petition and set aside the impugned order passed by the learned DMIC Jalandhar dated
So
25/5/21.
whether 138 is for the recovery of debt?
No, it is not for recovery. My IBC is not for recovery. The object of IBC.
Forget about IBC.
No,
I'm talking about NI Act.
no, but the fact section. No, man, it is not. The answer
It is
is no.
not. Suppose if the fine or compensation is not imposed,
My lord.
you can't be punished for issuing a check.
No, my lord. My says, what is the purpose? What has been informed in that case of P. Mohan Raj, my lord?
I have read that. That's why I'm putting a question to you.
But my issue is this act of this moratorium has been put up for a specific purpose.
That is for the recovery of debt.
No, my lord. My lord, that's the main issue. Is
Yes, yes.
But
Please
this
come
is
to
also-
that.
My lords.
Please come to that.
Section 96 again, my lord.
Yes, sir. Any legal action or proceeding pending in respect of any debt.
It's only any
That is
debt.
for recovery of debt. That's what I'm saying.
My lord, but my lord, it doesn't.
So that means,
But it doesn't.
how that will cover section 138?
Or 138 is also it is for recovery of a debt.
Sorry,
in a
sir.
Sense, in a sense, my lord,
Sorry,
because,
sir.
Because
Sorry, sir.
But
It is not for recovery of debt. That's why a punishment has been provided.
But my says that proceeding under 138 could not have been initiated when I had informed the court that there is a moratorium and there is a
Sir,
debt. which has been
please.
defined. Not now. My lord,
Sir, please
My lord,
wait for 2 seconds. Right? or else I am ready to keep quiet. No difficulty.
No, my lord,
If you have decided that you will speak out only and you will not listen to the court, fine, sir, no difficulty.
no, my lord,
We cannot compel you to listen to me.
I'm sorry, my lord.
Please come to section 11, 3 subsection 11.
Debt
Hmm.
means a liability or obligation in
Hmm.
respect of a claim which is due from any person and includes a financial debt and operational debt.
Hmm. Now please come to 12.
Default.
Hmm.
Default means non-payment of debt when whole or any part or installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor as the case may be.
Now come to 94. Now please keep these two definitions in mind, sir.
My lords.
Hmm.
Section 94. Application by debtor to initiate insolvency resolution process.
Hmm.
A debtor who commits a default.
A default.
My lords. As per
Now
section
please keep the definition of default in mind.
My lord.
Right?
My lord.
Non-payment of debt.
Not non-payment of debt. May
Whether-
apply.
Whether
Sorry.
Section 138 of
Hello.
Negotiable Instruments Act
My lord.
has anything to recover the debt.
My lord, it has been for that only purpose that the check has not been-
Whatever your personal perception about 138 may be,
It is a crime. It is for a criminal
it is
act
a
of-
crime. That
it
is
a criminal
all.
act for not honoring the commitment which has been done by
Right.
issuing a check, my lords.
Right.
My lords.
And in order to protect a person, a rider has been imposed that a check must have been issued in respect of a debt, a legally recoverable debt. That is all. It is not for the recovery of debt. There is a distinction between 138 and IBC section 94, 95 and 96.
My lords.
How can we stop the criminal proceedings for issuance of a check? This is not for recovery. We are not saying that since you have failed to deposit the amount or clear of the amount, therefore you are being punished.
My-
The ultimate conclusion would be that since you had issued a check with insufficient funds,
my lords. This is a crime because of that.
That is all.
Impacted. My lords,
that is a completely different act.
if my lord would permit me for a moment,
Yes,
the scheme of the act of IBC is with regard to my lords because the Supreme
that is with regard to the civil liabilities.
My lords may kindly therefore my lords,
Whether non-payment of debt is a crime under IBC?
no my lord, this is not a
No crime. It is with regard to the civil liabilities, right? Once the proceedings have been initiated, then 96 would come into picture.
Now the effect of 101 and 102, 103 would have to be seen, my lords. What does it say?
Uh-huh.
If that's the main issue is, my lords.
Yeah, yeah.
Once the insolvency proceeding has been, that is PIRP, that is personal insolvency resolution.
So that means you will be absolved.
Yes, my lord, from both the liabilities.
बताइए.
My lord, I wouldn't be. It
अरे
would
पढ़
be-
दीजिए ना.
it would be a clean slate, my lord.
अरे please read it out
Correct.
from the section.
Section 115 says, my lord, what will be the effect of order of adjudicating authority on repayment plan? That is for PIRP, my lords.
Mhm.
Thereafter, my lords. My lord, 119, discharge order.
Mhm.
On the basis of repayment plan, the resolution professional shall apply to the adjudicating authority for a discharge order in relation to the debts mentioned.
Discharge in relation to debt.
Yes, my lord.
Nothing from the criminal liability.
My lord, that what has been held by the Supreme Court, I would share that.
आप
Madam
उतने
Dilip
पे आ जाओ ना,
Srivastava.
डायरेक्ट आओ ना यार. आप तो पंजाब एंड हरियाणा का हाईकोर्ट दिखा रहे हो मेरे को. एंड प्रिंसिपली विदाउट गोइंग थ्रू द रीजन, प्रिंसिपली मुझे थोड़ा सा गड़बड़ लग रहा है.
Not actually this.
I have not gone through the reasons. Ultimately, I may convince myself with the reasons. But you have read out only 4 lines, which did not strike to me.
I would.
Now, please come to, you were referring to which section?
119, madam.
119. Now, please tell me the judgment on which you are placing
But this is the
replies.
judgment wherein section 99 to 100 have been undertaken to be the challenge to virus of these provisions of personal insolvency were taken care of by the Honorable Supreme Court and it has been.
Sir, please point out the judgment
Paragraph.
in which it has been held that once the insolvency proceedings have been initiated, no proceedings under section 138.
This is the one, 2021 Supreme Court P. Mohan Raj.
बस उतना दीजिए ना.
Okay,
उतना
sir.
दीजिए. जी सर.
But the distinction between, I had first, why I had given Punjab and Haryana in this.
जस्ट अ मिनट सर, आप इस पे आइए ना.
Sorry.
138 को कहाँ कंसीडर किया है?
Not the first pacitum itself says, my lords.
हम्म.
But it is with related. I would just clarify.
अच्छा,
one
sir.
issue, my lord.
Your
Yes, it-
contention is
Sorry.
Your contention is that the complaint under 138
come under proceedings, my lord.
was not maintainable.
Was under proceedings, my lords, because the issue
Yes,
there is, my lord,
proceedings under section.
but that judgment is with relating to a moratorium under section 14, which is passed by the honorable NCLT after admission, my
भाई
lords. And
प्लीज यार, अब आपके पास कॉमा फुल स्टॉप नहीं है क्या?
I'm sorry,
नहीं है तो फिर बात करो, हम भी चुप रह जाते हैं.
I'm sorry, my lord.
Please come to your order annexure P3. That is the initial order.
A2, my lord.
Order issuing notice
Yes, my lord.
when it
Page
was
40.
passed.
It was passed on 16/4/2024.
Please come to the judgment passed by the trial court
Yes, my lord.
when it was passed.
The judgment was passed on 13/3/2024.
समझ में आ गया क्वेश्चन मेरा? नहीं आया तो मैं समझाऊं फिर.
Sorry.
आपके ट्रायल कोर्ट के जजमेंट के बाद का नोटिस है ये. A3.
No, my lord, that is
Why saying no?
no, my lord, that is not which,
What?
but I had produced the last order. had
I
produced
don't know, sir. Whatever you have produced,
My
that
lord,
I'm. Mister, please
my lord, I would produce.
don't raise your voice. You have not filed the documents.
My lord, I had filed that.
Yes, you have not filed the documents. Whatever documents you have filed, I'm looking at those documents. That is all.
But this is the last.
Final, Mr. Counsel, please bear with me. If you have chosen not to file the document, then don't shout at me.
I'm not shouting, my lord.
And-
I'm sorry, my lord, if my voice has risen. My lord, I'm
Now, once you have relied upon a document which is dated 22/3/2024, and by that order, the notices have been issued, and that order is subsequent to the judgment passed by the trial court under 138 of Negotiable Instruments Act. It is your mistake if you have committed, if not placed all the documents on
Let me
record.
May I clarify this issue?
Right, sir.
Page 28.
I am not supposed to read in between the lines.
Not reading, but I'm very specific on affidavit.
I am not going to consider any affidavit when the documents are there with you.
Document is there in appeal, my lords. My lords, may kindly.
Forget about that.
My lord, may kindly bear for a moment, my lord, for a moment, if my lords can bear for.
अच्छी बात है, sir. बताइए.
Page 28, my lord, the appeal which has been filed in which this order has been passed. If my lords would see the ground of appeal, the first paragraph, my lord, at page 28.
Hmm.
The first, my lord.
Hmm.
The appellant being a guarantor of Shri Gita Textile who has committed a default in non-payment of so-and-so, section 94 has been filed before Honorable NCLT Indore bench for initiating undergoing the insolvency resolution process wide company petition number so-and-so, wherein as per section 96, the interim moratorium starts from the date of filing qua personal guarantor, that is with effect from 14/10/2022. As effective on the date of impugned order dated 13/3/2024 and is still in operation as on the date of filing of the appeal memo. I had produced that to show, my lord, that it is still pending. I mean, these documents are very well,
ठीक है ना?
and I had already, my lord, the judgment itself says that I had produced the document of initiation of insolvency before the trial court itself, before the learned judicial magistrate itself. So there is no dispute, my lord, that my moratorium under 96 starts from the date that is 14/10/2022. It is the admitted position, my lord. Before my lords, I had produced this order only for the purpose that it is still.
Sir, in which paragraph it has been held by Supreme Court in the case of Mohan Raj that after the initiation of proceedings under the IBC Act,
My lord,
the 138 proceedings will not be maintainable. And you cannot be punished for the check issued by you.
my lord, I would certainly.
Please point it out.
If my lord would come to first passitum, I would just brought down the paragraphs also, my lord. The first passitum just below, my lord, the what has been held by the Honorable Supreme Court has been written. If my lord would permit, I would read from there first, and then we'll bring that part of the judgment. Held gravamen of a proceeding under section 138 NI Act, comma, though couched in language making the act complaint of an offence, comma, is really in order to get back through a summary proceeding, comma, the amount contained in the dishonored check together with interest and cost, comma, expeditiously and cheaply. Thus, a quasi-criminal proceeding such as that is contained in chapter 17 NI Act would, comma, given the object and context of section 14 IBC, amount to proceedings within the meaning of section 14(1)(a), the moratorium therefore attaching to such proceeding. Thus, the legal impediment contained in section 14 would make it impossible for such proceeding to continue or to be instituted against the corporate debtor itself. Therefore, for the period of moratorium, no 138, 141 NI Act proceeding can continue or to be continued against the corporate debtor because of the section 14 bar, and so forth. And section 53 of the IB code, my lord, that is for the company, that is CIRP, Corporate Insolvency Resolution Process. It says, my lord, that the company would be given a new slate, all the matters pending as on the date of approval of the resolution plan would be deemed to be closed.
जी सर, जी सर. This judgment is by
By Justice Nariman, Justice Sinha, and Justice.
Is there any judgment contrary to it?
No, my lord. As on date, my lord, I had, since I can submit at bar, my lord, that there is no on this count, my lord. On the contrary, I would be, therefore, I was saying.
It would have been better for you to say that you have not searched out for any contrary.
My lords, may kindly.
It would have been better for you to say.
My lords,
Don't make a statement at the bar.
May I make a submission addition to it, my lords?
There is a contrary judgment by 3 judges bench passed in 2023.
My lords, may kindly consider, my lord. This is a judgment on section 14 of moratorium. That's what my say is, my lord. This is on.
It is yes, that is also a judgment on the same lines of the same bench. And you have made a specific. You have made a specific submission that there is no judgment.
But to the best of my, I had added.
It would have been better. It would have been better for you to make a statement, that, sir, you have not, or you could not lay down your hands.
Therefore, I had.
There is a specific judgment against you, and in that case, P. Mohan Raj was considered.
I couldn't have married since.
That is the difficulty. You people don't make researches and then start arguing the cases.
That has been considered by the same bench.
It was beyond reconciliation के भाई वो सब बंद कर दो उठा के.
My lords are referring to a judgment in which it has.
I don't know. I am not supposed to tell you.
My lords, may kindly.
Sir, please. I have already told you there is a judgment of the same bench.
In that judgment, it has been said that section 14 will not apply to guarantors.
Sir, please.
My lord, sir.
Sir, please. आपने judgment पढ़ा नहीं है और आप कहते हैं you are trying to distinguish it. How that is possible, yaar? That means you must have read that judgment and now you are showing your ignorance. If you have not read, then you can't make any distinction. And if you have read and you are trying to make a distinction, that means you have suppressed that fact that there is a judgment contrary to the judgment which you are citing. And in the subsequent judgment, the judgment passed in the case of P. Mohan Raj was considered.
Therefore, I was making submission.
Fine. It was not my duty to tell you, but I have told you. That is all.
If
don't take it otherwise. I have told you. Otherwise, I would have written it in the judgment and fine. Sure.
May I humbly submit, my lords?
Please,
the issue is, my lords, that judgment which my lords are considering to be a judgment.
Sir, if you have not read that judgment, then please don't make a comment.
My lords, may kindly.
Sir, please.
I'm submitting, my lords. Let me be given a chance, my lords.
Oh, sir, sorry. I'm not here to tell you.
Then my submissions may be considered at least, my lords.
That
this is a proceeding, that the order of P. Mohan.
No, sir, मैं कर तो रहा हूँ ना.
If I may make a submission that I would be at my lord's hands to.
Sir, you have already held that once the proceedings have been initiated under IBC Act, then this proceeding under section 138 of Negotiable Instrument Act would also be covered in the word of proceeding. Therefore, in the light of P. Mohan Raj, even the judgment passed by the trial court was nullity or it was not maintainable, and therefore the imposition of condition while granting bail to you, that is also bad.
I would add, therefore,
the
only issue which has to be added is P. Mohan Raj has considered section 14 of the IBC, wherein it has been against the company, and subsequently section 96 is a condition which is not available in section 14, and it includes the words proceeding. Section 14 doesn't include the words proceeding, my lords. It has been interpreted by the Honorable Supreme Court that it would be, but whereas section 96 is very specific, wherein interim moratorium applies from the date of filing till the date of admission, and from the date of admission, 101 final moratorium would apply. So therefore, in that case, in that context, my lords, I had referred to the Punjab and Haryana High Court judgment, wherein specifically this distinction between P. Mohan Raj and section 96.
2023 वॉल्यूम 10 SCC. मेरे को दे दीजिए। MCRC 177917782/2024. This application under section 482 of CRPC has been filed. Consider the submissions made by counsel for the applicant. In order to challenge the condition of deposit of amount or grant of or suspension of sentence, amount of rupees 13,73,890 for suspension of sentence, the only contention of the counsel for the applicant is that since the borrower has initiated the proceedings for insolvency under the Bankruptcy Code 2016, therefore, in the light of Section 96 of the Code 2016, the debt cannot be recovered. Considering the totality of the effects and circumstances of the case, and in view of the fact that merely because the initiation of proceedings under the Bankruptcy Code 2016, the signatory of the check would not escape from his liability by citing the dissolution of the company from it is held that the conviction recorded by the trial court was not bad on account of initiation of proceedings under Bankruptcy Code 2016. For the similar reason, the appellate court did not commit any mistake by directing the a petitioner applicant to deposit an amount of rupees so and so as a condition precedent for suspension of sentence. Accordingly, no case is made out of warranting interference.
Yeah.
The application fails and is hereby dismissed.
I would not say, my
Yes,
lord,
sir.
to change the order, my lord, but only for the purposes, my lords.
Yeah,
This
please.
judgment says, my lords, it is with regard to that section 14 moratorium will not be made applicable to the guarantors. It doesn't mean this section 96. Therefore, my lord, the Punjab Haryana High Court has now further dealt with that issue and it has relied upon this judgment also of Goenkas, my lord, and said that it is.
सर प्लीज मैंने 75 सुनिए 75 पैराग्राफ में सिग्नेटरी वर्ड को उन्होंने होल्ड किया है ही विल नॉट रन ही कैन नॉट रन अवे फ्रॉम हिज लायबिलिटी
That is
फाइन
I'm sorry.
once you have issued the check
I'm sorry.
once you have issued the check whether you are a guarantor or not guarantor it hardly matters.
I'm sorry. Much obliged.
Next.